You're watching The Court Leader's Advantage, a video podcast for court professionals and by court professionals. Brought to you by thecourtleader.net in cooperation with NACM, the National Association for Court Management. Since the death of George Floyd, this country is agonized over divided perceptions of the police and criminal justice. One view sees systemic bias, with problems that need institutional change. An alternative view sees isolated events that need individual investigation and limited corrections. Although the courts have not been in the spotlight recently, this might be a good time for some introspection. Can the impartiality of the courts remain intact, or is this an opportunity for some proactive improvement? What is the state of our courts regarding systemic bias? And what advice do we have for others moving forward? I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This is the first of a two-part episode on the courts and systemic bias. So let's join our co-host and our panel. Today I'm joined by my co-host, Mr. Charleston Carter, Trial Court Administrator for the Superior Court in North Carolina's 26th Judicial District in Mecklenburg County. Today's panel includes the Honorable John Pacheco, Judge of the Superior Court in San Bernardino, California; Ms. Linda Romero-Soles, Retired Court Executive Officer for the Superior Court in Merced County, California; Ms. Alina Clark with the Prosecutor's Office for Genesee County, Michigan; and Ms. Elisa Chin Gary, Clerk of the Superior Court in Mecklenburg County, North Carolina. Welcome to you all. Elisa, there is currently a national movement to dramatically reduce the use of cash bail as a pretrial release option. Has Mecklenburg County tried to reduce the use of cash bail? And if so, how has it worked out so far? And what do you say to those who think that the use of cash bail should remain as an essential part of pretrial release?
Thank you, Peter and Charleston, for facilitating this important discussion. I'm also appreciative to NACM for driving such an important topic among court personnel. Our discussion today centers around systematic bias, and I'd like to take just a moment to define it as I understand it. Systematic bias is also known as institutional bias, and it's embedded in the everyday practices and workings of a system that create advantages for some groups and disadvantages for others. Historically, the use of cash bail in Mecklenburg, and I would say all over this nation, has disadvantaged the poor, those who do not have the financial means or the support system to pay a cash bail. One can literally sit in jail for a week, a month, several months on a low-level misdemeanor that eventually may get dismissed by the court or by the district attorney. So in Mecklenburg County, it has proven to be a system that has disadvantaged the poor and disproportionately impacted people of color. My office sits immediately across from my jail. And as I look out the window, I know and receive a daily report that 78% of the population that's incarcerated that are African American and are Hispanic, when in actuality, those populations make up less than 50% of our population overall. So definitely disproportionate. Mecklenburg County has worked really hard to implement strategies as they partner with the MacArthur's Foundation to implement some strategies that would help safely reduce our jail population. And so we've done some things in addition to cash bond that have proven successful. And to those who would say that it should be an integral part, I would say to look for alternatives because meaningful alternatives are out there.
Judge Pacheco, what about efforts to reduce the use of cash bail in San Bernardino, California?
Thank you very much, Peter, and thank you for inviting me for this podcast. Thank you, Charleston. First of all, as you know, California is pretty forward in thinking, and on August 28th of 2018, our then Governor Brown, he implemented and signed Bill SB 10, which actually eliminated the monetary bail system. However, because of the referendum, it got stalled a little bit, and SB 10 has now been placed on our November ballot of 2020 of this year. Notwithstanding that, our county did implement a pretrial release program, and we worked with the probation department, and it was similar model to the Virginia pretrial risk assessment program. We determined from the probation department whether the person was a flight risk and whether or not they were a danger to the public. So based on certain factors, the person would be categorized as a low risk, a medium risk, or a high risk. So this information was provided to the judge from the probation department to allow the judge to determine whether or not the person should remain in custody or not, or be released without bail or without any terms and conditions. So surprisingly, when we were doing this, believe it or not, we only had 11% of the people that we released that were reoffending. So actually 89% is a pretty good number so it was working very well. Unfortunately, COVID hit us and we ran out of money and we weren't able to continue with it. So now we kind of have a modified version, but also our state Supreme Court have issued a COVID bail modified schedule, because right now our jails, there's huge amounts of COVID exposure. And so we are really looking at that. Last thing we want to do is get them infected, and it would just be ridiculous. So that's what we're doing. I'm proud to say our whole state is pretty active that way.
That makes a good segue into the next question for Alina. Many argue that systemic biases remains either racial, gender, or both in pretrial release decisions. Do you think systemic biases in pretrial release decisions exist?
I think that the one thing that we have to always kind of keep in mind is the system was created by people that had one perspective. You can go into courthouses that even now have bathrooms for women on separate floors, because when the courthouses were created, women weren't even allowed in the courthouse, let alone to serve on a jury. So a lot of the rules that we build upon in the legal profession are created with one perspective. And in Michigan in particular, as I imagine many other states are, I think the legislature had the intent of trying to take into account everything when it created the court rules and the laws that govern pretrial release. But if you look at the list of things that a court has to consider, for example, I'm just going to read a couple of them if you'll indulge me. Prior criminal record, record or appearance or non-appearance of court proceedings, flight risk, history of substance abuse, defendant's mental health conditions, seriousness of the offense charged, defendant's employment status, availability of responsible members of the community, facts indicating the defendant's ties to the community, any other facts bearing on the risk or non-appearance or danger to the public. And I think that if you are a judge that doesn't necessarily have an awareness of why, in particular, members of the LGBTQ community may not have an employment history or substance abuse issues or non-family ties, you're already putting them at a disadvantage, because a lot of the LGBTQ plus community are shunned by their family, or worse, have to go through conversion therapy. And if you don't know what that is, Google it. It's horrific. So when these are the factors that you have to consider as a judge, you're already limiting the ability for somebody who may be a minority, lower income, or LGBTQ, because they don't have that stuff readily available to them. You don't understand why they don't have a family connection or somebody that can come in and say, I'll vouch for this person, they will come and stay with me. That's usually, or many times, can be limited for them. But on top of that, if you don't have an attorney that even thinks to ask their client, what's going on with you, or the questions to ask a person, like, why don't you have family members? They can't advocate for you. So that's why implicit bias training is so important for even the beginning stages of the criminal trial process.
Thank you, Alina. Linda, what are your thoughts on bias in pretrial decisions?
I believe that bias still exists in pretrial decisions. Research indicates that Hispanics and Black defendants are more likely to be jailed than white defendants, because As Elisa mentioned, many lack the financial resources to post bail and as a result remain in jail. This is unfortunate because when they are detained, it affects their employment, if they have jobs, housing, as well as it financially impacts their families. And also judicial awareness needs to be raised on a potential impact that bias has on pretrial decisions. I believe that bias will continue until we move from a monetary-based bail system to a risk-based bail pretrial system, which was recommended in the COSCA 2013 policy paper on pretrial release. A risk-based model seems less discriminatory as everyone is on a level playing field. And as Judge Pacheco mentioned, SB 10 is on hold due to the referendum here in California to overturn it and on the November 20 ballot. So we'll have to wait and see what the voters decide after the election.
I really like what you said, Linda, in regards to talking about Blacks and Latinos. And there are some studies that report that young Black and Latino males, especially unemployed, to be sentenced more than other defendants based on other ethnicities for drug and property crimes. Do you see a systemic bias in sentencing?
You know, that's an interesting question. There have been several studies conducted on this subject. One study focused on sentencing outcomes in large urban courts, which I found pretty interesting. It showed that Hispanic defendants are sentenced more similarly to Black defendants than white. Ethnicity effects were largest in drug and property offenders. I believe there is a correlation between interaction of race, ethnicity, and type of crime, and Blacks and Latinos tend to be more harshly sentenced than whites. I was reviewing the California 2019 DOJ statistics on felonies and misdemeanors, and the data showed that Hispanics were the largest group arrested for both categories. And interestingly, white were the second highest and Blacks were third.
Elisa, what are your views on sentencing and potential biases?
I believe that the evidence is overwhelming and that it's undeniable. In fact, I've often heard it called the color of justice. My office has a value statement that says how we see people is how we serve people. In fact, one of our Superior Court judges who does a lot of work around building systems of equity and implicit bias calls it an assembly line or a conveyor belt that defendants often find themselves on. And he says that it takes someone to see you to interrupt the flow of that conveyor belt. And it sounds a little flippant to say it that way, but I listened to his words very carefully. He says that the only way to get off the conveyor belt is for you to be seen as an individual and not just as another widget that's going down that assembly line. And that can happen if a police officer sees you as a person and not as a criminal, or an assistant district attorney sees you in that same light, or your defense attorney makes people see who you are and your humanity, and don't just see you as the usual suspect, or a judge who sees a person as redeemable. And when you are seen, it can make all of the difference in how someone is sentenced. He also goes on to say that it is quite often in his courtrooms that members of the public who stand before him who are white have a greater likelihood of being seen.
Thank you, Elisa, and I like how you captured that, which brings me to the next question for George Pacheco. If a person is seen is one thing, but then we talk about data. Data-driven sentencing information will be required on extensive outgoing statistical analysis on sentencing. There is no national data collection on sentencing by courts right now, but the data can exist in a case management system database. Should it be a role of the courts to conduct this kind of statistical sentencing analysis?
Thank you, Charleston. That's a very difficult question, and I'll tell you why. While statistical analysis definitely serves as a purpose in assisting in developing some guidelines for us in sentencing, it is so important and imperative that a judge maintain his or judicial discretion to determine on a case-by-case basis. But having said that, without any type of training, bias training, implicit bias training, it may affect that sentencing, and that would be wrong. But some of the considerations that we weigh in sentencing may be, as previously stated, the substance abuse or mental health problems, and we try to find additional tools or alternatives rather than putting people into prison or jail.
Thank you, Judge. Elena, do you think courts should conduct widespread statistical analysis on sentencing?
I think that it would be wise because I agree that judges need to have some discretion, but I think that when you get things like implicit bias training, one of the main things they teach you is you can't fix what you can't see. So if you're not seeing what the problem is, and because a lot of lawyers and judges are obviously lawyers, we base our decisions on logic. And the best way to persuade somebody that, hey, this is a problem is to provide empirical data. So, I mean, it's going to be a major task, and I don't know where all the resources will come to do that, but I don't know where else we would start, because if you can't convince people just on a humanity-based level that this is happening and they refuse to see it, I don't know any other way that you're going to convince them.
Thank you, Elena. Which brings me to my next question. We're talking about studies. And Linda, studies show that most justices of the state Supreme Courts are white men, which is about 55%, and white women, which is about 29%. Is this composition of state Supreme Courts an instance of systemic bias? If so, what is the solution?
Charleston, that's a good question. I believe times are slowly changing, and we're going to be seeing more female justices in the state Supreme Courts. For example, in California, we had our first white female state Chief Justice, Rose Bird, in 1977. 34 years later, our present Chief Justice, Tania Cantil-Sacayue, is the second female and first Asian Filipina American to serve in this role. In addition, there are currently 3 female and 4 males on our state Supreme Court. Of the total 7, 5 are minorities. The same holds true for the 58 California trial court CEOs. When I started in the courts, there were hardly any minority CEOs or female CEOs. Now there are 31 females and 27 male CEOs, and 15 of them are minorities.
I think that this is also really important to point out how incumbent it is on us as attorneys to really lift each other up in terms of like the minority bar associations and the women lawyer associations and things like that, because the general public, as sad as it is, I don't think really knows that much about the judges that they're electing. That's why you see so many elections that are won based on name. And we have to go out and educate the community and support the candidates that are diverse to be either appointed to these bench positions or out there advertising and campaigning for them. Because if not, people, like normal people, just are not going to realize what they're electing. It's just the way it is. If you ask any random person, they probably have no idea who their district court judges are, who their circuit court judges, let alone their appellate judges in the Supreme Court. I mean, that's, I think it's so important that we do that. And I know like the Women Lawyers Association in Michigan, we only have 33% of our bench is women. And it's even smaller for minorities, and it's even smaller for women of color. So, and LGBTQ is, you know, almost non-represented at all for a number of reasons. Not everybody's really comfortable with, you know, putting it out there what their orientation is. So if we don't do this to help, you know, spread the word and open the doors and lift each other up, I mean, it's going to take even longer. And I do agree it's getting better, but we need to do more as a legal community to help this situation improve.
Helena, I like how you say we need to do more. And George Pacheco, as you've heard the startling statistics of the ethnic makeup of Supreme Court, does this cause any concern to you?
Not with our state Supreme Court, perhaps our national our U.S. Supreme Court maybe, but not with our state. As Linda correctly pointed out, we have a lot of different minorities that are involved. We do have a justice that will be retiring shortly, And there's a lot of talk about replacing that justice with a qualified, of course, always qualified LBQT justice. And our court is, again, I said it earlier, we're very forward thinking. The other thing is, I happen to personally know our justices. And the reason why is because they do outreach. They come out to our community. We invite them to be guest speakers. They always volunteer to come out. You get a chance to break bread with them and get to know who they really are. And we're very fortunate that way. And I know that I sent Peter a statement that was made, unequivocal statement that was made by our state Supreme Court justices, where they will not tolerate racism of any kind. And they talk about the inequity about the indigenous people and about Black people, because when our Constitution was created, we were not citizens. We could not vote. That has changed all the way back to Standing Bear from the Trail of Tears, when he said, I am a man. I am not a piece of chattel. I have a right to have land. This is my land. It is so important, and our justices are great that way. So I'm so proud of our current Supreme Court justices.
Thank you, Judge. And since we're talking about racial disparities, usually you cannot define racial disparities by one single part, whether it's in one particular part over here or over there. But how do we acknowledge the cumulative nature of racial disparities?
I think the first thing that we need to make sure that we're doing is that we listen. Right now, we are so fortunate to have a platform that people that did not have a voice before are being heard. And I think that it's incumbent on the majority of people to close their mouths and to listen and validate those feelings and acknowledge that there is systematic racism in this country, whether you want to admit it or not. And that is the very first step, is we have to respect each other and respect that perspective that maybe you don't have any idea what this person's speaking about, but at least give them the respect to be able to say it, and then listen to what they think that maybe the solutions may be. There's some very good ideas out there, and there are some amazing people that are doing podcasts, webinars, speaking engagements. Educate yourself. Go out there and understand that there is so many other perspectives besides your own, and I don't care who you are. And that is, I think, the very, very first step that we need to make sure that we're doing.
Elisa, how do we address the cumulative effects of racial disparities?
Well, first, I would echo everything that Elena said. Building the knowledge base is the foundation for any practice or action that we take. I think, secondly, there needs to be a building of the stated commitment. What I heard the judge speak of earlier about what is happening in California is very inspiring. A group of leaders to come and stand together and said, this will not happen on my watch. So building the commitment is important. You spoke to a single bias shown at a single part of the court process versus the cumulative effect. I think it's also a good idea to look at those single parts. We know that there's a cumulative effect, but there's also data that can inform us every step of this process. So mining the data and understanding where in processes that there's a greater likelihood of bias gives us an opportunity to interrupt it at that place. So I think looking distinctively at every step of the process is also a way of battling against accumulated bias.
And I also think that we need to hold each other accountable. Like, I think that there needs to be, mechanisms in place that when something does, we do notice that it's happening, that we're holding each other accountable. And I know, like, the American Bar Association has done a lot with Resolution 113, with having people take these pledges and making sure that you are consistently looking at where you're at, and that there are, there's data for you to review, and that when you're not doing what you said you were going to do, that you're held accountable.
Alina, I like how you said holding people accountable. So accountability is important. So I must ask Judge Pacheco, biases can cut across multiple players within the justice system. How should courts communicate with all players across the system? Are there specific strategies when one player is not interested in collaborating?
Well, it's interesting that I got asked this question because last week, our county, the outreach committee of the court, put together a town hall on racism and civil unrest. We had the head sheriff, we had the head DA, we had the head PD, we had a county board of supervisors, we had a legislator, we had the president of the county bar, and we had someone from social services. And believe it or not, they all 100% agree that there is problems with systemic bias and racism, and we need to confront it. And they all agree that we need to do it as partners. I know you said players, but we are so fortunate to have partners that come together and all agree that we do need to do something. Also, of our 58 counties, 3 of our counties, and I'm proud to say San Bernardino is a forerunner for creating an elimination of bias committee, which is going to include all our partners. And these partners are going to go, and the whole purpose of doing this is recognizing, hey, we have bias. There's biases. It's systemic in our system, and we need to understand it. Like Elena said, the number one goal is you have to understand it and accept that it is a problem. If you don't accept that it's a problem, it's not going to help you. That because people honestly believe there's no issues of racism, there's no issues of bias. And to me, that's just their own bias taking over their thoughts, because reality is everyone that I know agrees that there is bias.
Thank you so much, Judge. I like that you have indicated that acknowledgement must take its course. So, Linda, how do you think we should communicate with all the partners in the system?
I think Judge Pacheco articulated it very well. I like his ideas on what his county has done. And what's important is the composition of the committees. You make sure that you've got different minorities in your committees. One other thought that I have is, in addition to the meetings, is I would encourage to have them have an expert either from the National Center State Courts or Judicial Council as a facilitator to conduct the meeting. Because I think sometimes it's nice to have someone from the outside facilitating those.
Elena, you mentioned earlier about the LGBTQ community. Biases against the LGBTQ community is different in that some hold very strong religious beliefs opposing this community. Given the strong religious undertones, what solutions are available, if any?
Well, yeah, that's the question. Are there any? The difficult part of this is that when we talk about it, you think, well, this shouldn't be an issue because we have separation of church and state. So I've worked in government my entire post-law school career, and you would think that that would be the case, but it isn't. And when you're not a member of this community, you don't really realize how the very small things that not even just your religious perspectives, but you get to talk about your significant other, but we may feel that we don't get to participate in those conversations because of how you're going to judge us or the retaliation or how we're going to be treated. And they're very, very small undertones that you don't necessarily notice. So how do we fix it? I mean, the first thing I would say is certainly implicit bias training. And we have to be more comfortable with being around stuff that's different than what we are. I mean, I've had a boss that wasn't my direct boss, but stopped performing marriage ceremonies because this person didn't want to marry people and then not marry the gays. Well, imagine as a member of this community how that made me feel now every time I'm around that person. That wasn't necessarily just religious based. I think for this particular person it was. But you have to kind of start to learn to have a little bit of a filter with how those small things will change an entire way somebody's going to be able to interact with you. And if you don't have that type of training or, go out and, I don't know, go to a rally or talk to somebody that may be a representative of that community and say, hey, can I have a cup of coffee with you and we talk about this? And have a real dialogue about things that are, you may not realize are offensive, but they are very hurtful and make people feel very uncomfortable. And I think that would probably be a really good place to start.
Thank you, Elena. Elisa, what are some possible solutions that you think as relates to dealing with bias against the LGBT community?
Well, I can only echo what Alina has said. I would suggest going beyond implicit bias training. We do quite a bit of that here, learning about how our brain works, how we categorize, unfortunately, people, and what we can do to mitigate that. But I've encouraged our judiciary to go a step ahead of that, as well as our court personnel, and to actually take an implicit association test. They are available in this category. So learning what your biases are, because we're so quick to say, not me. And there's someone in our life that we love, and we think that because we love that person, we're exempt from this bias. But the implicit association test really helps us uncover those subliminal, subconscious things that we don't think of. So I would suggest that. I would also suggest, as in many of these biases, the solution is being proximate. Understanding and having a conversation. Because until you do, all that you really have is assumptions. But having a narrative, because you are proximate to people in any given group or population, makes that an easier task.
The last question for me is this. Based on what you all have indicated, you have recognized a systemic bias and you have called it by name. Alina, you had mentioned about as it relates to being neutral when you address someone, and you gave the solution of just using general terms. Is there anything that you would like to add to that as relates to enacting something statewide?
I think that that's a good place to start. We're still so new with understanding the LGBTQ community in terms of rights. We were only just given Title VII protections this year. So I think that we're going to see a lot more solutions and a lot more ways that we can start opening the gateways to giving equality to the LGBTQ community and actually respecting us, because if you even look at those lawsuits by the Supreme Court, the employers didn't contest the fact that they were fired because they were either trans or gay. I mean, they were very clear, like, this is why they were fired. And that's, I think the first step is that we're going to have to realize that's not okay. We've got to hold each other accountable. We've got to call somebody out when they're saying something, making a gay joke, those types of things. And I personally think that a really nice thing that you can do to help the LGBTQ community is adding in the pronouns in your signature line. If we start creating an environment where it's norm to acknowledge that people are different than us and that it's okay to put your pronouns in there, that I think that a lot more people will start coming forward and finally feeling a little bit more comfortable with accepting who they are and being open about who they are. And that's really the kind of culture that we need to start working on.
Linda, you had mentioned about how the perception of perceiving someone based on what they may be wearing with designer clothing. What advice will you give to stop that type of perception statewide?
Well, I have to toot the horn for California because they do an excellent job on training judicial council staff. And so they have a lot of ongoing training that employees are required to complete every 2 years. So I would say ongoing training, implicit bias training, and awareness.
Elisa, you mentioned too, you indicated jury selection as well as judicial district. What advice that you could get to solve that solution on a statewide level?
That's a huge question. I would say that some of that really begins with the individual. When it's hard to say that because we know that these kinds of biases are built into a system and it takes system change, but it also takes someone to recognize that that change is needed. One of the things that we have done, it isn't related to jury discrimination, but we have been mindful and intention of changing the language and the pronouns that we use in our workplace policies. And once we did that in one jurisdiction, we said to ourselves, well, wouldn't it be nice if that were embedded in all of the policies and administrative orders and things that we see in writing having more of a neutral language that identified folks. So I do think that it takes people to push these changes. You mentioned earlier about, and we each named places in which we saw systemic bias that we had not named before, but there's so many more. There's so many more. We could spend the day talking about that. What I will say is that it's important for us to have a lens that is always looking for those biases, because you have to diagnose it, see it before you can acknowledge it. Then you must acknowledge it and find practices to eliminate what we know to be something that produces unjust results.
And finally, Judge Pacheco, you mentioned about the glass ceiling and breaking that glass, and you addressed the good old boy system. How will you be able to address the good old boy system statewide?
As I said earlier, and I think my other speakers here said the same, it starts from the top. The top of the state, our Supreme Court, and I hope Peter does publish this, they issued a statement in June where they unanimously said, clearly, we will not tolerate any form of racism, any form of bias. They unanimously say that, all seven, and they all signed it. And our PJ, Michael Sachs, fantastic PJ, because he is a forward thinker. He's one of three of the 58 counties that said, you know what, we need to start an elimination of bias committee. That's where it starts. It starts from our leaders. If our leaders don't push us, you know what, we're never going to go anywhere. But if we have good leaders like we do in California, and I know Linda will agree, the judges get training. We get training on how to address people from the LGBT community. People, we get training, and that's where it starts. We acknowledge that we are all equal, and we should all be treated fairly and equally. Thank you very much for having me.
My thanks to Elisa, Linda, Alina, and Judge Pacheco today for sharing their thoughts on courts and systemic bias. Also, my thanks to my very able co-host, Charleston Carter. The statement by the California Supreme Court on equality and inclusion and the American Bar Association's Resolution 113 are both posted on the NACM podcast webpage under additional resources for this month's episode. I invite you to review both of them. Join us next month on September the 24th as we discuss diversity in the courts. And by the way, we want to hear from you. Do you have a comment about this month's episode? Do you have an instance of systemic bias that you think needs to be discussed? Email us at clapodcast, that's all one word, at nacmnet.org. We'll try to get your comment on in a future episode. I'm Pete Kiefer, and thanks for watching. Thanks for joining us today. The Court Leader's Advantage is a regular podcast on courts and court administration. Today's episode will be available on the NACM website, on YouTube, on Facebook, and on Twitter. If you have questions, comments, or ideas for future episodes, email us. Our address is clapodcast, that's all one word, at nacmnet.org. I'm Pete Kiefer, and on behalf of our guests, the Court Leader's website, and the National Association for Court Management, have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily reflect the position of the National Association for Court Management. Thanks for joining us today. The Court Leader's Advantage is a regular podcast on courts and court administration. Today's episode will be available on the NACM website, on YouTube, on Facebook, and on Twitter. If you have questions, comments, or ideas for future episodes, email us. Our address is CLApodcast, that's all one word, at nacmnet.org. I'm Pete Kiefer, and on behalf of our guests, the Court Leader's website, and the National Association for Court Management, have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily reflect the position of the National Association for Court Management.